Great. Good morning, good afternoon, everyone, and even good evening, wherever you are in the world. We're going to give people a few more seconds to join, but as they're joining, I'd like to introduce myself. I'm Monette Zard. I'm the director of the program on forced migration and health at the Heilbronn Department of Population and Family Health at Columbia University's Mailman School. And I'm delighted to join you and welcome you on behalf of Columbia and our partners at the Zolberg Institute on Migration and Mobility at the New School for Social Research and Cornell Law School's Migration and Human Rights program. We're delighted to welcome you to this week's symposium entitled 1 Year On, Human Mobility and Human Rights in the COVID-19 Pandemic. So a little over 1 year ago, the scope and scale of the COVID-19 pandemic was becoming apparent as first China and then Italy and then the US, particularly New York, grappled with the spread of the virus. We began to witness a number of trends in national responses, which raised profound implications for all of us, but in particular for migrants, refugees, and asylum seekers. First was the reflexive and default response on the part of states to unilaterally close international borders and limit mobility internationally and internally. Second, from the earliest days of the pandemic, we saw attempts by politicians to assign a nationality to the virus and attempt to scapegoat certain groups, usually foreigners or marginalized groups. And there have been many examples of stigma and xenophobic violence during the current pandemic, which the UN Secretary General has described as a tsunami of hate. And third was the sense in those early days by states, but also amongst the general public, that to battle a public health emergency, almost anything goes. Anything was permissible in terms of restrictions on rights and civil liberties. So it was apparent to many of us at that time that there was a need to affirm the importance and need for a law and human rights-based approach, not just because it was the right thing to do, but also because an effective public health response requires it, both to build predictability into the response and to ensure that everyone in society feels safe to come forward, to be tested, to be treated, and to be vaccinated. So a group of international lawyers came together, and many of them are speakers and panelists at this symposium this week. They came together to spell out some key legal principles that should guide the response to the pandemic. These 14 principles, as they've become known, garnered over 1,000 signatures from legal and migration scholars across the globe. We hope that the principles have been an effective tool in advocacy and outreach, but there's no question that the terrain remains contested. And this symposium has been organized to assess where we are 1 year on and to spotlight what challenges remain. So I'm going to hand it over to my dear colleague, Professor Alenikov, to speak to some of those current challenges ahead of us.
Welcome, everyone. We'll be together, I hope, for the next 3 days for this for the symposium. You know, as extraordinary as the measures were that were taken against citizens of a state in terms of limiting freedom of movement and other kinds of restrictions because of the pandemic, we live in a world where obviously states take care of their citizens first before seeing to the needs of non-citizens, despite fundamental human rights norms of non-discrimination. And in writing the 14 principles, we knew this would be true. And so we put non-discrimination and the right to health at the center of the project, because we were already seeing policies that pushed up against these established international human rights norms. And so, while some of these troubling policies have waned, some still remain. So we still see continued denials of access to territory for asylum seekers, the United States being the most notorious about this, pushing back literally hundreds of thousands of people who've gotten to the border with no process whatsoever. And we see continued detention of immigrants in many countries. It threatens their health because of COVID. But taking stock a year later, we now see new challenges as the response to the pandemic has evolved. I'll just in bullet form identify 4, which I've drawn largely from the papers that we'll be discussing over the next 3 days. So, of course, probably most important is access to vaccines as an aspect of the right to health. And we've seen within countries and among countries gross disparities in terms of access to vaccines. And we then need to wonder to what extent this is even worse for non-citizens of these countries. Secondly, discriminatory denial of COVID-related benefits to migrants, usually irregular migrants. Some states have extended benefits to some immigrants, but it hasn't been the kind of non-discrimination that we think human rights norms demand. Thirdly, the impetus that COVID has provided to new forms of biosurveillance, particularly as a part of border control, which implicates norms of rights of privacy. And fourthly, interpretation of the right to refuse medical treatment as it applies to states that now condition immigration or will condition immigration and refugee status on proof of vaccination. Most of these issues were not anticipated when we wrote the 14 principles. So one of the questions we'll have to address over the next 3 days is, are these situations covered by the principles, by a robust interpretation of the principles, or might we need to add some additional principles to cover this evolving world of state restrictions and discriminations in new areas? Over to you, Ian Kissel.
Thanks so much. And I'd be remiss if I didn't begin by thanking the team at Columbia, Mona Zard and Jen Ostrowski and others for the work that's gone into this. But welcome all. And I wanted to just give a few words about how we've organized the next few days. First, on format, we realize that all of us are suffering under Zoom fatigue, as well as heightened care obligations, and ironically or not, the inability to actually be mobile and gather together in person to discuss these principles. So we've designed a symposium to try to engage that in several short, punchy sessions on successive days, sessions that also we hope facilitate active participation in the chat and Q&A. I'll try to make that reminder a number of times throughout today's sessions so that we can make those discussions more engaging. We hope you'll tune in to an interesting discussion or two, or all of the discussions over the course of the 3 days, and take a break from whatever else your morning, afternoon, or evening holds. Second, but equally important on content, and really in dialogue with the themes that Alex just mentioned, is that we selected 4 topics for this symposium that we think are of urgent and current relevance to governments and policymakers, civil society, and the international community as they continue to respond to the pandemic at this moment, and engage the rights of people in the context of mobility. So our principles or principles that we've yet to articulate as among the key pieces in guiding state response. So those panels or sessions will focus on freedom of movement in the public health response. So that'll be today, digital health technologies in public health surveillance, and the right to health and issues of access and equity. That will be tomorrow, and then access to vaccines. And we will close with a roundtable of reflection featuring a number of the authors of the 14 principles and some of the speakers of our sessions. Again, because of the format, we hope you'll come for one or and stay for all, or come to all sessions. And I just want to underscore again that we hope you'll be actively engaged in this discussion via the chat and the Q&A. Those features of the webinar platform are available along the bottom band in your Zoom window. But in addition to hoping to facilitate an active discussion, we also want you to engage for a second reason, which is that we're delighted to be coordinating with the editors of the European Journal of International Law blog, Equal Talk, and expect to publish a parallel symposium adapting this week's proceedings in the next month or so. So your responsive comments and questions in each of the sessions will be very useful and directly inform the revisions of all of our symposium authors. So that concludes our introductory remarks. I think we can, unless the co-conveners suggest otherwise, or have anything to add, I think we can just jump right into the first panel. So For those just joining, good morning, good afternoon, good evening. So my name is Ian Kissel. I teach at Cornell Law School, and I'm part of our Migration and Human Rights program. And I'm really pleased to be moderating this first session today. What I hope really will be a robust discussion with Professor Chaloka Beyani and Professor Leah Zamore, who I'll introduce more fully in just a moment. We'll focus today on freedom of movement in the public health response. And I want to underscore, as I just mentioned, that we really do hope that you'll actively engage either via the chat with comments or questions or the Q&A feature of this webinar platform. Again, those features are available along the bottom band in your Zoom window. In fact, we're going to be reserving the balance of our time in this short session to questions and discussion. And as I shared just a moment ago, we are delighted to be coordinating with the editors at the European Journal and hope to publish a parallel symposium adapting this week's proceedings in EJL Talk. And so the discussion today will inform those papers. So our first panel takes as a point of departure, the fact that the pandemic has simultaneously challenged the notion that human mobility is an inevitable constant of life in the 21st century. But it's also revealed that migrants are essential members of our community in ways that perhaps not as many of us as we would have liked recognized before the pandemic. The health and well-being of migrants, the pandemic has shown, is as vital to the safety of our communities as is anyone else's. No one is safe, as the saying goes, unless everyone is safe. And unfortunately, states have failed to adequately respect, protect, or fulfill the rights that will respond to those needs and that dignity, including for refugees and other migrants. And perhaps the most significant illustration of that is the role that borders themselves and the potential for mobility have played in this failure, as well as, of course, internal mobility. So, since the declaration of a pandemic in March 2020, and in the absence of, in many cases, evidence-based or lawful justification, states around the globe have sealed borders to migrants and refugees, and of course to migrant citizen expatriates seeking to repatriate, as dramatically played out just in recent weeks with Australia's India travel ban. UNHCR at the height of the pandemic reported that 168 countries fully or partially closed their borders, with 90 of them, so just under half of the United Nations member states, making no exception for the right to seek asylum and access effective status, territory or status determination procedure. So around the world, we saw closed borders, leaving thousands of migrants, refugees stranded, queued, pushed back. Some border controls arguably followed a fundamentally discriminatory logic, engaging those rights that Alex noted are the cornerstone of the 14 principles, echoing a deeper and long-standing intersection between race, migration, and global public health. Observers also pointed to restrictions on departure and not just entry as evidence of the proverbial shifting border, extending the reach of sovereign authority beyond territorial edges. Others argued that the pandemic brought deterrence measures against refugees to their logical conclusion and essentially suspended asylum in many places. Fortunately, of course, not all states have solely implemented retrograde measures. Progressive steps have included calibrating border closures to ensure certain categories of migrants can continue to pass. Most notably, I think the recognition of the right to family unity and the rights of the child in a number of border regimes. But as this crisis continues to unfold, international human rights law is obviously a vital tool for evaluating these state actions and shortcomings in the pandemic response. And so I look forward to the discussion of these themes for the next 40 or so minutes. And I want to again emphasize we are welcome and active discussion and question and answer period. So without further ado, and noting that full bios will be posted in the chat, we'll hear first this morning from Chaloka Beyani of the London School of Economics, who has worked and published extensively on human rights, migrants' rights, refugee rights, among many other areas, and recently, among other things, served as the UN Human Rights Council's independent expert or special rapporteur on the human rights of internally displaced persons. After Chaloka, we'll hear from our discussant, Leah Zamore of New York University, who likewise has worked and written on human rights, migrants' rights, and refugee rights. Chaloka, let me give you the floor and welcome, and thank you for your participation.
Well, thank you so much, Ian. And I also extend my thanks to Monette at Columbia, to Alex at the Zolberg Institute as well, as to Leah in New York. I think your opening remarks have actually contextualized what the problem is and what the issues are. The issue of mobility in the era of COVID-19 is quite important. And of central importance, of course, is freedom of movement in the response to public health measures that have been introduced by almost 186 states by the last count, and all of which have imposed some kind of measures or restrictions on freedom of movement in the context of entry, as well as in the context of internal movement. So it was inevitable that the scope of freedom of movement would be affected by restrictions placed by states on grounds of public health. And because of this, restrictions have raised international concern on the implications of human rights due to the COVID health response for nationals, third country nationals, for migrants, asylum seekers, and in particular, undocumented migrants. It is in this context that the assertion and reassertion of human rights has become more important to try and at least condition and subject the public health response to human rights. So an early and timely intervention, of course, came from the project that developed the 14 principles and the auspices of Columbia, Cornell, as well as the Zolberg Institute. And all the heads are also here to account for their actions and selective behaviors in leading up to the principles. So it's in the context of these principles that the paper reflects, in particular, those principles that relate to mobility. Principle 4 address restrictions on movement between states, and it state quite categorically that states are required to ensure that restrictions on mobility adopted in response to COVID-19 respect the rights of all persons to live in state and to re-enter their home state. And Principle 5 address restrictions on movement within states. That is, in responding to COVID-19 pandemic, states must respect the liberty of movement of all persons within their territory. And in the paper, I make the point that these principles have their sources in international human rights, descending from the Universal Declaration of Human Rights, Article 13, and codified in Article 12 of the International Covenant on Civil and Political Rights. And we also find similar assertions of these principles in the regional instruments, whether it's Article 12 of the African Charter on Human and People's Rights, or the 4th Protocol, the European Convention on Human Rights, or Article 22, for that matter, of the Inter-American Convention on Human Rights. So it's quite clear that of these principles, the right to live in country applies to nationals, asylum seekers, and third country nationals. But the prohibition on arbitrary deprivation of one's right to enter their own country applies strictly to nationals of the state. And indeed, human rights jurisprudence does suggest that the prohibition of entry in relation to the nationals of a state may constitute inhuman and degrading treatment. However, the point is that the restrictions themselves are necessary to protect several other grounds: national security, public order, public health, or morals, or other rights and freedoms. But a state that invokes restrictions on these grounds, of course, must also be prepared to account for its behavior and conduct, and to be scrutinized in the way in which the restrictions would be applied. And here a number of questions obviously arise. First, are there real grounds of concern that a risk or threat to public health exists because of COVID-19? Second, is the restriction a component of an objectively agreed health law that is necessary to protect public health on grounds of COVID-19 and goes no further than is necessary in order to do so? And thirdly, is the action taken to mitigate the risk or threat of COVID-19 spreading proportionate to the objective of being pursued, or could it be achieved in any other way, alternative means of healthcare, for example, not requiring a restriction on freedom of movement? And importantly, if an inward or outward ban is imposed with corresponding restrictions on internal movement and residence, would it not be incumbent on the state imposing it to monitor the situation, to ease or rescind it if it becomes clear that the threat to public health has eased or no longer exists? I think beginning in the United Kingdom this week from yesterday, people are now allowed to at least hug, to visit each other. So the restrictions are easing, but the due diligence test isn't important in that regard. A fundamental requirement of the covenant, at least, is that any restrictions placed on the public interest grounds must also be compatible with other rights under the covenant. And that's a far-reaching standard, from family unity, reunion, prevention of detention, prevention of the whole issue of ill treatment, in the context of the prohibition of torture, inhuman and degrading treatment, the protection of the right to life. That's an all-encompassing aspect. But I argue that that aspect also extends to the rights that are covered in the Covenant on Economic, Social, and Cultural Rights on the basis of indivisibility and interconnectedness of human rights. And indeed, in its remarks on the COVID pandemic and human rights, the Committee on Economic, Social, and Cultural Rights did state that the COVID-19 pandemic vividly illustrates the point of the indivisibility and interdependence of human rights. And in this regard, we then have to pay attention to what the covenant says, because after all, the question of public health and the right to health is one that is enunciated under the covenant. And the covenant in this regard requires states parties to achieve the full realization of the right to health, to include necessary measures for the prevention, treatment, and control of epidemic, endemic, occupational, and other diseases. So the covenant obviously foresaw this and put in qualitative standards by which state behavior and state conduct would be measured. But the test of necessity in respect of the right to health replicates, or at least corroborates, the requirement of necessity in respect of freedom of movement under the Covenant on Civil and Political Rights. So there's a correlationship here, but this correlationship, I suggest, in my argument, is not one-dimensional. On the one hand, public health response must inform the nature of the restrictions on freedom of movement based on public health needs, such as the COVID-19 situational assessment, testing, tracing, isolation, quarantine, while also maintaining public health capacity to cope with the caseloads of COVID by creating conditions that would assure to medical service and medical attention and to all those in need. On the other hand, the Covenant on Civil and Political Rights and its tests of legality are also important, that having been informed by the nature of the restrictions to be applicable on freedom of movement, public health-based restrictions should be subjected strictly to the legality of restrictions on freedom of movement as well. So this obviously entails that the restrictions to public gatherings, isolation, quarantine, and the conditional easing of restrictions are subject to human rights criteria. Social distancing as well. So the lawfulness of these measures ultimately depends on the degree of restriction and whether that restriction does in fact vitiate other rights as the covenant provides the underlying bedrock to that. And yet how applicable and appropriate will these measures be in high density areas as well as in camps or settlements for refugees and IDPs? In these situations, restrictions, perhaps I suggest, would apply against movement into high density areas, camps for refugees or IDPs, whilst permitting freedom of movement within the camps or settlements. And it would also follow that humanitarian personnel working in camps or settlements for refugees or IDPs would be screened for COVID-19 and take preventive measures to prevent COVID spreading. Some countries have imposed curfews. The legality of those curfews is much more about the degree of the restrictions. the duration of the curfew, the timing of the curfew, and also measures taken to enforce the curfew. In places like South Africa, Kenya, India, and Zambia, police forces acted with brutality to enforce curfews, which went beyond what was proportionately accepted. In this sense, then, what has happened after the 14 principles were enunciated in the context of human rights, getting to the end of my presentation? First, we had a statement from the Human Rights Committee in which the committee addressed essentially the question of derogation and states of emergency. This is not a part that I have covered essentially in the paper, but it's important to note that the committee reiterated the principles of notification, of proclamation of a state of emergency, of proportionality as between the measures taken and the exigencies of the situation that is required to deal with COVID. The Committee on Economic, Social, and Cultural Rights took the position that COVID pandemic illustrates the importance of the indivisibility and interdependence of all human rights, and that the pandemic is clearly a global threat. But even in that context, the committee did caution that there are multiple implications for the enjoyment of civil and political rights, and some of the measures taken by states to combat impose severe restrictions on freedom of movement and on other rights. For the Committee on Economic, Social, and Cultural Rights to touch on freedom of movement clearly indicates, I think to some extent, the merit of the argument that I was trying to make. Not just about indivisibility, interconnectedness, but the way in which restrictions under one covenant inform restrictions on the other covenant. The African Commission on Human and People's Rights specifically addressed the issue of asylum seekers, refugees, and migrants in its statement on COVID, and expressed awareness that special measures must be adopted to prevent asylum seekers, refugees, and migrants from contracting the virus, and called upon states parties to the African Charter to act to ensure that vulnerable categories benefit from all preventive measures, including the provision of facilities for washing hands, disinfection, the issues of vaccines that Alex spoke about early on. The Council of Europe made a proposal that is yet to be adopted on the assessment of the level of the risk of COVID, and determining the appropriate movement restriction that would be necessary, as well as monitoring those restrictions, as well as enforcing them. So as cardinal as freedom of movement within the EU is, the proposal actually does acknowledge that member states adopted unilateral measures to combat COVID, departing from the centrality of common movement within the EU, and that the measures taken by states included restrictions on entry to other member states or specific requirements such as quarantine. They were applicable to cross-border travelers, including those moving for economic purposes, and that the restoration of freedom of movement in the context of the 2016 Schengen Border Code would also allow the temporary introduction of border checks. There are other measures as well taken by the EU, which are not essentially human rights based. On its part, finally, the Inter-American Commission on Human Rights and the Special Rapporteur called on states in the Americas to prioritize public health and comply with their own international human rights obligations while making decisions or adopting policies to approve, purchase, distribute, and provide access to vaccines. So its statement was made very much in the context of human rights, protection of the right to health, restrictions, and access to vaccines. So the emerging picture since we drafted the principles a year or so ago is that there's now much more awareness of the applicability of human rights to deal with the COVID-19 pandemic. And I think of the importance of human rights mechanisms, checking upon states and ensuring that restrictions are not pervasive and do not derogate the essential quality of freedom of movement between states as well as within states. Thank you very much.
Thank you so much, Chaloka. Before Leah inviting you to take the floor, I just want to take an opportunity to remind participants to feel free to address questions or comments to all of us in the chat or via the Q&A feature. But thank you for those remarks, Chaloka, and without further ado, we'll go right to Leah for the response. Thanks so much.
Great, thank you. I'm delighted to be here. I want to also start by just thanking Columbia, Cornell, and the New School, not only for bringing us together last year to write the principles, but for making sure that it wasn't just actually a one-off initiative, as important as that might have been, but actually a basis for this ongoing discussion and a kind of platform for advocacy, even a year later. So thank you sincerely for that. And I also want to thank and congratulate Chaloka on his paper. I have to say, I find it really refreshing to hear and read a human rights analysis of the issue of freedom of movement, which I think, among human rights lawyers has been the dominant approach, but within the kind of broader political discourse of the virus and of the response to the virus, I think has been woefully missing. I'm also quite heartened actually by the statements you just read at the end and that are at the end of your paper, where you do see human rights bodies really stepping into this space and acknowledging that there are serious human rights implications for some of these movement restrictions. Others have already named many of the movement restrictions, and I think by now most of us are quite familiar with them, but I will just say one thing, which is the degree to which they are completely unprecedented. So IOM came out with some analysis recently, and just by March of last year, the end of March of last year, there were 43,300 restrictions, which averages out to roughly 224 per country. That's an enormous amount of restrictions. Understandably, most of the globe was in and out of lockdowns for most of last year. On that point, I will say that I think that the lack of public outcry around the curtailment of movement on such a broad scale is notable. I think it's quite concerning. I think it sort of begs questions of human rights advocates about political messaging and the degree to which some of our legal arguments actually resonate with public opinion, especially in light of the fact that public opinion actually stayed quite favorable to governments as they were imposing these kinds of restrictions. Now, one reason for that, I think, and an obvious one, and Alex also mentioned this, and Chaloka, you do a very good job of making clear, is that free movement is not an inviolable right, that it can be curtailed in certain circumstances, and that in fact, many of those, tens of thousands of restrictions are in fact reasonable, that COVID is a legitimate threat to public health, and that, stopping people from gathering in big numbers, especially indoors, but in various ways, requires certain kinds of bans on movement. We can understand, one way to understand the reasonableness of some of these measures, I think, is to look at the fact that in many countries, people actually banned their own movement before government stepped in to do so. So in New York City, where I am based, ridership on the subway, for instance, plunged before the government actually imposed a lockdown. And in fact, the government never shut down the subway except for 2 hours a day in the very late early morning, and yet ridership stayed very low. So people sort of voted with their feet on some of these restrictions because they were in fact reasonable in light of both the government and people's own perceptions of the risk to their own health and to public health. Yet we also know that many of these restrictions were legally dubious, draconian, extreme. In fact, some of them were more extreme than some of the platforms of the farthest fringe anti-migrant political parties. And they were adopted more or less overnight with very, very little, as I said, public outcry. And I think that begs a number of questions that are important to get at. I think, and it's already been mentioned today, but xenophobia obviously plays quite a role here. Sort of the fear and hatred of foreigners and people who are different, allows governments to impose restrictions without a sort of mass political outcry if the citizenry already or can be convinced that those fears are in some way legitimate. I also think, though, and this is, I guess, my main point, that we can't really understand this dynamic between, a bundle of restrictions that are in some way reasonable, and then another bundle that are not, without also looking at the kind of political economy dynamics that are at play here. And so I think we can see this in three ways. One is just the level to which, for instance, restrictions have already been lifted for business travel and tourism, sort of leisure tourism, but have stayed imposed for immigration and asylum. Now, again, that has kind of xenophobic undertones to it, but it also has a very class-based undertone that restrictions on poor people remain in place and restrictions on people with disposable income and political power don't. I think another way to see this is the difference between restrictions on labor movement today and the complete lack of those kinds of restrictions on the movement of capital goods. So if we compare, for instance, the sort of media frenzy around the stoppage of the Evergreen in the Suez Canal, or the truck backup, the lorry backup between the UK and France, where there was a real media outcry about any sort of restrictions or any kind of getting in the way of the movement of goods and capital, compared to the return of asylum seekers to Libya, where they were bombed at the port and put back in prisons, I think is also telling. And again, it's a kind of reinforcement of an underlying system that allows certain things to move freely across borders and mainly poor human beings not to. And I guess that brings me to sort of my last main point, which is that many of us have experienced COVID as a crisis of immobility because of all of these restrictions. But for a lot of other people, it's actually been a crisis of forced mobility. And so again, there's different kinds of sort of pandemic migrations that have happened. We have seen, for instance, mass returns of Afghans in Iran to Afghanistan, in the hundreds of thousands within a few months. Similarly, Venezuelans have fled Colombia back to Venezuela for different reasons. We've seen asylum seekers be stranded, as Alex mentioned, in the US case, where people are just stuck in Mexico. And then that's just one example. And then we've also seen the return of labor migrants as economies contracted because of lockdowns. So for instance, South Asians that were working in the Middle East or the Gulf back to South Asia. And then internally, we've also seen some, almost incredibly huge. In the case of India, people say it may have been one of the biggest mass movements of people since the partition, when lockdowns were imposed and migrant workers in the cities had no way to survive. And so they fled to the rural areas. And we've seen similar dynamics, for instance, in Bangladesh and other countries, which is a complete reversal of decades and decades of migratory trends that most people actually thought were all but immutable, this kind of urbanization, migration as an urbanization phenomenon. And now it's actually kind of unclear, given the extent of the economic crisis that countries are facing, how temporary those kinds of movements are. And yet there's very little of the kind of assistance or public health response that's actually following people where they've moved to. In part, I think, because of this perception that this has been an immobilizing crisis rather than one of upheaval, which is not true for everybody. So I think I will stop there because I'm very excited about the discussion.
Wonderful. Thank you so much, Leah, and thank you both for this discussion. I suppose I might open with a question for Chaloka and a reminder to participants. We already have some questions coming in the chat and the Q&A, but feel free to put additional questions or comments in that we can use to continue this discussion. But let me begin with a question for Chaloka, or really a question for both of you about derogation and how to think about the function of derogation in the many of your, or the balance of your remarks, I think, Chaloka, focused on the application of the framework in the absence of derogation. But of course, you noted in the latter half of your remarks the importance of the reminder to states of the limitations on the scope of appropriate derogations, but many states did derogate on Article 12, in particular in the ICCPR framework, noting that their emergencies were triggering a suspension of the application or a derogation from the application of Article 12's provisions on the rights of freedom of or liberty of movement. So I wanted to ask to what extent are the norms relevant to evaluating state response sort of in light of the derogations, or are we focused here primarily on looking at the application of the overall framework sort of in the context of where states did not derogate. You could talk a little bit about how we think about those derogations as informing the last point you made, the sort of the relevance of human rights, the increasing relevance of human rights to this issue.
May I start? I don't know whether Leah wants to go first, but
No, please go ahead.
thank you very much. I think I stayed away in the paper from derogations other than alluding to what the Committee on the Human Rights Committee has stated, as I wasn't actually quite sure whether derogations would be addressed in the context of the preparation of the principles. And I think I do recall that it was Professor Guy Goodwin-Gill who had worked on the question of derogations. But the two instruments in relation to the issue of mobility in the context of COVID actually coexist. Whereas restrictions are very much a feature of Article 12, derogations are a feature of Article 4 of the International Covenant on Civil and Political Rights. Restrictions are part of the corpus of the right of movement within and between states. And the question is whether or not the restrictions imposed by way of exceptions actually take away the right completely. So the rights to exist in the background as a basis for measuring the conduct and behavior of states. Whereas in the context of derogations, derogations require a state of emergency in the first instance, and not just the mere passing of a law to impose restrictions. There would have to be an officially proclaimed state of emergency. Notice would have to be given about the proclamation of this state of emergency in terms of how long, what does it affect, does it involve curfews, or does it involve complete banishment on mobility. Thereafter, of course, derogations take away the right other than non-derogable rights, such as the right to life or prohibition of torture, inhuman and degrading treatment, slavery and enslavement, and rights of that character. So the nature of the derogation is such that states have immense powers. And of course, freedom of movement is a derogable right, which would mean that measures of derogation go beyond restrictions to allow states, for example, to impose complete bans on movement, on entry, as well as on departure, if they so wished. And I think a typical example of COVID-related states of emergency measures are those in the United Kingdom, where at least every 6 months or thereabouts, Parliament has to renew the measures, debate and see whether as a monitoring and safeguard aspect, the measures are still required or still proportionate to that. Derogation would also require that the measures be non-discriminatory on all the known grounds, on grounds of race, religion, gender, birth, or other status. So one set of measures directed at migrants in the context of derogation and which differentiate the treatment of migrants in relation to others would obviously be discriminatory and disproportionate under derogation measures. The final point I would make in the context of derogation is that, of course, the measures taken must be proportionate to the nature of the threat. In this case, the exigency, the threat is that of COVID. So they should be proportionate to combating COVID and should not be a cover-up for immobility completely or for targeting asylum seekers and migrants in other areas. And I think that, just looking at the normative base of those two aspects is what I would address. And I'm sure Leah is more conversant with the political economy of both restrictions as well as derogations. Thank you.
Yeah, I don't know if you have thoughts on sort of derogation.
Sure. Yeah, maybe I'll just briefly sort of reinforce actually what Chaloka just said on 2 points. So one is that even in the absence of a global pandemic, states have huge power to enforce border controls. And exceptions to that actually are things like asylum. But obviously, in a public health moment like this, that power goes up. So often for good reasons, but often also not. The other one is just to really underscore the point Chaloka makes also in his paper, that assessing the legitimacy of a derogation really requires a kind of comprehensive approach. So I give the example, for instance, of in a lot of countries actually that have, at least up till now, done surprisingly well in the public health fight against COVID, including countries that I think a lot of us were extremely worried about, that have high population densities and weak public health systems. And yet the economic crisis is actually the main threat. And in some situations, it's actually becoming a hunger crisis. And we now have 4 or 5 countries with people in conditions of famine today. And lockdowns and these kinds of measures can actually contribute to a threat to life in that sense. And so weighing the balance between a public health threat, I think, can only be done if you're also taking into consideration these kind of knock-on effects, particularly in the economic sphere.
Wonderful, thank you. We do have some questions coming in, and feel free, participant or attendees, to continue to use the Q&A and chat functions at the bottom of your Zoom screen. The first question we have is about an issue that's come up in both sets of remarks, really, which is about kind of the state enforcement of curfews and mobility restrictions. In particular, Chaloka, you spoke about the brutality of the law enforcement of curfews. And the question is, how might the relationship between public health and law enforcement be reimagined in the wake of COVID-19 abuses, or sort of in the wake of state response to the pandemic and to mobility restrictions? And you can take it in either order if either of you have thoughts.
I think that the measures to be taken by law enforcement officials, the police in particular, obviously have to be correlative to the COVID response as a public health measure. But the responses that we have seen sometimes exacerbate the risk of COVID. People who were said to have breached the curfew limits, instead of allowing them to go home, were rounded up and put in rooms where proximity actually did not count, which risked the spread of COVID in those circumstances. So that judged against restrictions on freedom of movement, the requirements of public order in particular, would also be subjected to the same restrictions, but much more bearing in mind that the right to health is clearly involved. It also means that those restrictions which impinge on other rights come in play. As I did state, one important requirement under the covenant is that any restriction must be compatible with all other rights. So if you beat up people because they've breached a curfew or because of the COVID situation, as happened in India or Zambia, you're subjecting them to cruel, inhuman, and degrading treatment, which is a breach of the covenant. And equally, some of the measures taken risk the right to life in terms of the beatings. Some people were put in detention when in fact there was no state of emergency which would have warranted the deprivation of liberty. Again, unlawful. So I think the point here is that we can pontificate about all the rights that are involved, but there's also just a culture of brutality around law enforcement officials that seems to be impervious to human rights and human rights thinking, almost everywhere. I think it's a uniform aspect, because I have seen in the context of the demonstrations that have taken place in the Netherlands, in the UK, that are COVID related, I mean, the reaction by the police has always been disproportionate in terms of the use of violence against peaceful demonstrators. It's also important I did put perhaps in brackets in the paper, to note that the case has been brought against Switzerland on the issue of the COVID measures, not so much under the grounds of restrictions on freedom of movement, but under the grounds of freedom of association and assembly, Article 11 of the European Convention on Human Rights. And again, because of the high-handed measures by the police, whereby people have not been allowed to assemble and to demonstrate for COVID-related reasons. So I think the principles are still important, but the importance, I think, has to be drawn into the behavioral culture of the police and the law enforcement officers in relation to measures of COVID.
Leah, anything to add?
Sure. Well, yeah, just once again, I agree with Chaloka, so he's making my job very easy. No, so when it comes to sort of excessive or brutal state enforcement, it seems again that COVID is actually just being used as a pretext to discipline, harass, exploit unfavored groups, politically marginalized groups, and in that sense, sort of recourse for victims of that violence is sort of a similarly problematic phenomenon than it was before the pandemic. The pandemic obviously exacerbates it in various ways, including, for instance, the fact that judicial systems were suspended in a lot of countries or went remote, and that caused all kinds of access issues. I'll also say, though, that there's an interesting dynamic when the state, at least a responsible state, doesn't take responsibility for enforcing some of these restrictions, which is that, for instance, in the United States, now you've got a situation where CDC guidance says that fully vaccinated people don't need to wear masks, but the state is not actually going to enforce that. So it's actually going to be up to private companies, basically the clerks at the grocery store, or, the essential workers who are going to have to actually somehow figure out how to police people, decide who is and who isn't vaccinated, and these kinds of things. So there can, this is obviously nowhere near as an extreme of a problem as excessive police violence. But there is also a problem when the state actually doesn't fulfill its responsibilities to enforce legitimate public health measures and leaves it to, essential workers who are busy actually doing other things.
Thanks so much, both. We do have a number of questions coming in, so let me go to another one in the chat here, or in the Q&A. So as far as the questioner is aware, very few European states have introduced an Article 15 European Convention on Human Rights derogation to the right of free movement under protection under the provision of Article 4, Article 2, or Article 5 as a result of COVID measures. As the questioner notes that the Romanian Supreme Court required that country to make such a derogation, but that seems to be exceptional in the European context. And the question really is back to our question of brief discussion of derogation in the ICCPR context, and whether there are similar temporary derogations by states under the ICCPR, and then more broadly, whether there's pressure on states that have restricted free movement that they must comply with the rule of law and make the derogation, or I might add to the question: is there pressure on states that have made a derogation but have modified measures to update their derogation to conform to the kind of changing circumstances, Chaloka, that you discussed earlier? And either of you can take it first. You both shared some wonderful thoughts on derogation.
Well, I'm happy to yield to Leah if she would like to go first. I've seen the question as well. I think it's implicit in what I actually said earlier on, that yes, European states have not invoked derogation in the context of Article 15 of the European Convention on Human Rights. Nor have other states under the Article 4 of the International Covenant on Civil and Political Rights. They have not officially proclaimed states of emergency. But the reason why the Human Rights Committee was prompted to make the decision that it did was that the measures taken by states under the banner of restricting freedom of movement in one form or another, in fact, amounted to derogations without the conditions that derogations require, i.e. an official notification and proclamation of a state of emergency, which means that the states involved sought to evade some of the more pertinent scrutiny that would come from either the Human Rights Committee or indeed the European Court on Human Rights or the Inter-American Commission on Court. For good measure, the African Charter on Human and People's Rights does not have a derogation clause at all. It merely has restrictions, at all times. So there may be overlapping obligations in terms of which system here would be applicable. But I think the questioner, Espeth, is quite right in stating that European states have not formally derogated under the European Convention, nor have they done so under the International Covenant on Civil and Political Rights. But the measures taken to restrict freedom of movement, in fact, have amounted to derogation in certain instances.
Leah, feel free to jump in, but I'm struck about the connection with your earlier remarks of the political failures of the human rights movement, and in the sense that one might have imagined derogation, as technical as it is, becoming an area where there was real pressure on governments to comply with that aspect of the human rights regime. As the principles note, and as we've already discussed, right, there is this sort of safety valve on the system to allow, in relation to some rights, permissible limitations or derogation entirely. And I wonder if I was just struck by your remarks on that, and I wonder if you want to share any further reflections on that piece of the puzzle.
Well, just to say that I think that is at least in part what may be going on. Otherwise states presumably would actually take the opportunity to justify what they're doing and sort of reinforce its legitimacy and legality by going through some of these processes. The fact that they didn't could suggest that they weren't really under pressure to justify what they were doing anyway, that there was no political backlash. And so, why bother, especially when, at least with some of the restrictions, they actually probably didn't have a very good case.
I want to switch to the question of monitoring and enforcement. We have a couple of questions. One about what enforcement mechanisms are available to the violation of the non-refoulement obligation in relation to asylum seekers as it pertains to mobility restrictions in the time of the pandemic. And then there's a more particular question about the Venezuela-Colombia border, but really that turns in part, at least, about the availability of data and monitoring to evaluate returns in the context of COVID. And I wonder if either of you have thoughts on that piece. We've talked a bit about state failures and monitoring state failures. We might talk about that, but I also wonder if there's a piece of the international response here that's been lacking, or that you might comment on. And I'll again open it up to either of you.
I think we have to take account also of the prevailing political environment since the onset of COVID-19, which essentially was populism and populist regimes pushing against human rights from about 2019 and before. And I think that COVID has given spacious cover to some of the more populist regimes to push against the agenda of human rights in ways that we didn't imagine before. The major organizations, NGOs like Human Rights Watch and Amnesty have raised concerns about COVID and human rights. And I don't think they've been listened to very much. We're witnessing a situation where the treaty bodies have not been able to meet because of COVID and finance-related reasons on the part of the UN. There's a pushback against special procedures, even special procedures, special rapporteurs and independent experts have not been able to undertake missions because of COVID-19. And in this environment, some states have sneaked in some agenda to push back on special procedures, introducing resolutions that would actually curtail the effectiveness of mandate holders. So I think it's in this context that the monitoring mechanisms themselves have been disabled at the level of the United Nations, although civil society has continued to play its role. But you need an alliance between civil society and the UN measures that monitor human rights. In the context of Venezuela, Latin America, I think there's probably, despite everything that has happened in Brazil, but the introduction of a kind of diplomatic visa or humanitarian visa for asylum seekers, which would make at least their conditions of flight and entry a little bit more amenable than is normal, could be applauded. But the action taken by the government of Venezuela is punitive in relation to its own citizens and refusing them re-entry on grounds that they left the country, which exposed, I think, the country's failures economically and politically. And that obviously stands in the face of the provisions in the Covenant, Article 12.4, I believe, that no one's right to return shall be arbitrarily withheld by a state in relation to a national of that state. And I think that the principles make that very, very clear. But accessions and monitoring and pressure, I think, has been affected by the cover of COVID, not so much COVID itself, but the cover of COVID, whereby states are using COVID, I think, to push against the human rights agenda, and also to disable the very institutions that are supposed to be monitoring human rights effectively.
So I agree. No, there is a lack of data. I have a project going on right now, actually just trying to survey some of these urban workers, well, the millions of urban workers, although we're not trying to survey all of them, but in Bangladesh who returned from the cities to the rural areas to just try to figure out, how are you doing? How are your families doing? How are the communities that you returned to doing? Because, in the hopes of that might actually inform some of the sort of economic response. But I also do think that the lack of good data can also be an excuse for inaction. So we know that this is the worst public health crisis in a generation, or in a century. And we know it's the worst economic crisis in about almost the same time period. We know people are hurting, and we know that predominantly people who are already hurting are hurting more. And we don't need to wait, I think, for perfect data to do something about that. And I think here, again, I agree that this requires a kind of mass mobilization, a literal global Marshall Plan, a kind of major redistribution of resources, not just vaccines, but economic resources to developing countries, in order for them to avoid what is essentially, I think, what we're looking at, which is a bit what happened after the 2008 crash, which is, an inadequate influx of international liquidity means years and years and years of austerity budgets, cuts to services, the exact kinds of things that the global North is actually doing the opposite of. And then a kind of almost a lost decade of hardship coming out of this, that there will not be recovery, I think, for most of the world in the absence of a program like that. And that, I think, we have the data to justify. We just don't have the politics.
So zooming in on sort of the politics and the international institutions piece of this, I wonder, on the mobility, on the front of restrictions of mobility, in addition to the human rights mechanisms that we've discussed, are there opportunities for that the pandemic has shown strengths or shortcomings in international institutions, more particularly connected to mobility? So IOM, UNHCR, the new UN network on migration, are there places there when that's be sort of the last question before we wrap up, that you identify opportunities for reform?
Well, I'm not so sure about opportunities for reform, but at this point, I'm a member of the expert group, the high-level panel on internal displacement, which was established precisely to try and reform and think forward on the better ways of protecting internally displaced persons. The fact-finding mission in the context of Libya, for example, which I'm also part of, has been affected by COVID, but at the same time, it's paying great attention at the issues that Leah mentioned at the beginning of migrants being forcibly returned to Libya, and Libya actually not being a safe point of embarkation. But I think in all of this, the humanitarian work has continued. I think that the IOM and UNHCR have continued to do their work in very difficult circumstances. I think the pushback faced by both of them in the context of asylum seekers is, of course, the complete negation, for example, of Article 31 of the 1951 Convention, whereby asylum seekers should not be penalized for illegal entry if they're coming directly from a country where their lives are affected. So the blanket restrictions placed by states on migrants in the name of COVID, I think, has affected the way in which they operate. IOM has faced similar issues in the context of migrants. But if there has to be some reform, I think we would start at the level of the Interagency Standing Committee, which is the body that oversees the field clusters and operations in the context of refugees, asylum seekers, IDPs, and others in need. I think the outgoing emergency relief coordinator, Mark Lockwood, made the statement that the agencies that sit on that committee and which he chaired are not actually accountable to anyone or to the people that they serve in the circumstances. They become a self-serving virtue, as it were. So I think that, yes, there has to be some forward thinking about reform in the system, about reforms in the cluster system, and the coordination of the UN mechanism, of which both IOM and UNHCR obviously are. At the cluster system, you only get few clusters that pay specific attention, for example, to internally displaced persons, camp management, protection, shelter. And ineffective protection for IDPs, of course, leads to more continued searches for asylum on the part of refugees. So there's a relationship there that needs to be looked into.
Thanks so much, and thanks everyone for indulging our going over by a few minutes. I'd welcome all of you back tomorrow at 9 a.m. Eastern, and please join me in thanking our esteemed panelists. Thank you, Chaloka. Thank you, Leah. It was really a pleasure discussing these issues with you. And attendees, I hope you'll join us for the rest of the symposium. Thank you.
Cheers.
Very much. It was a pleasure.
Thank you.